Good morning, everybody. Thank you for joining us for this webinar today, which is being presented by Thomas Gibbons. Thomas leads the McCaw-Lewis property team, having joined the firm in 2004, appointed a partner in 2008, and has been a director since 2011. He specialises in property and infrastructure law and focuses on complex development projects and property issues. Thomas has appeared as an expert witness in the High Court on land development issues, and his publications have been referred to in a number of court decisions. As well as his development project work, Thomas is known as an expert on unit titles, easements, and land governance issues. Thomas is also a board member for Survey Spatial, so I'll hand you over now to Thomas.
Thanks, Jenny. Good morning, everyone. Look, I'll go right in after that. Today I'm talking about unit titles, and they are a particular passion of mine. I've been working heavily in this area for the last probably 12-ish years, and do a lot of opinion work, do a lot of subdivision work in this area, and work on a lot of issues that come up, sometimes tricky ones. And having written a book in this area, I've been reasonably across the case law, and some of the cases have come down quite heavily on the job done by the surveyor or spatial professional. There's a lot I could cover. I've only got an hour, and I'm not even going to talk that whole hour. So what I'm going to do is pick up on some highlights. Some things I'll go over very quickly, and some I'll go over slightly more slowly. There are three key ideas I want to get across. And the first of them is about the concepts involved with unit titles. The second is this idea that unit titles are a method of subdivision. That's commonly how surveyors come across them. And if you open up a land law textbook, you'll hear about different types of tenure. You'll start with this idea of fee simple. Everyone knows about that. You often have cross lease second, because these textbooks were written at a time when cross leases were second most popular, and unit titles are often an afterthought. They are a method of subdivision and a type of land tenure, but they're also, as I often say, a mode of governance, a particular type of ownership with governance aspects involved. And land lawyers talk a lot about this idea of title by registration. This idea that if you have a record of title with your name on it, that is evidence that you own the property. You achieve title through the act of registration. And with unit titles, I like to say it's title by registration via governance. It's not just ownership or simply ownership. It's something beyond that. It's being part of something bigger. And I'll touch on that a couple of times as we go through. Some of these concepts are listed here, and some of them be very familiar, and some of them perhaps less so in day-to-day work. Obviously, issues like principal unit, accessory unit, which also gets called auxiliary unit sometimes, common property, and a unit plan. Those are the surveyor's tools of trade, I suppose, in this respect. Then we get onto some of the governance issues about this idea of a body corporate that every owner must join, the chairperson of the body corporate, the committee, which is there to represent owners in relation to the body corporate, and body corporate rules, which set out some rules relating to the development on an ongoing basis. Some are often enforceable and some not. Then we get into some other issues like building elements, things like roof and foundations and walls, which are part of the building. We get into the territory of incidental rights, so the fact that each unit on a unit plan has rights over the other units comparable to easements. And we have this idea throughout unit titles law, probably not so much survey practice, of ultra vires. And this is the idea that many things a body corporate does or doesn't do can actually be set aside as unenforceable. A body corporate actually has very limited legal powers and can only do certain things. And that's a key legal idea that you need to be aware of when setting up developments. So the purpose of highlighting these concepts is showing that this is a jargon-heavy area. and being across these ideas is absolutely critical. I've only touched on them here, but very important to be across them. I thought it was helpful to put up a record of title. Some of you be dealing with unit titles all the time, some perhaps less so. This is just a particular one that came across my desk the other day, and the key difference between a record of title for, say, a fee simple lot and a unit title is this idea of a supplementary record sheet. So front page looks relatively similar. We've got an owner, we've got an identifier, and so on. We've got a unit description, and then we have, I'll come back to the detail of the title, a old style unit plan. So here we have Unit A, Unit B, C, D, E, F, H. This was done under the Unit Titles Act 1972. It's actually largely in two dimensions, which is interesting, and there are further pages I haven't repeated here. But it's reasonably old school, and I'll come to a more recent version to highlight issues. But even this, if you look closely, we have the identification of some common property, and what is common property and what is very important. The case law that even if you don't mark something as common property, it is still common property. And the examples would be areas above the upper height limit or the lower height below the lower height limit. Those are common property, whether you mark them as that or not. We have an issue here on some of the dotted lines around building boundaries or eaves, which don't entirely match unit boundaries. And it was a topic of debate for some years over whether the unit could actually include areas that were not a building. It's very clear now that they can, and very common to do that. Common to include both a building and a garden or a storage area within the unit boundary. But that was a topic of debate for some years in the courts. Some other pictures. Unit titles are really about buildings. You've got to have a unit reference to a building. Didn't quite have the same level of strictness under the Unit Titles Act 1972, but definitely now. Having said that, unit titles are not just about high rises. They're used for all sorts of developments. This is a coastal one, and we have here the same concepts of principal units, like the main residential dwelling, accessory units, like a garage or a carport, and common access areas or common property. And whether that's in town, central Auckland, by the beach somewhere, it doesn't matter. Those concepts and principles remain the same. Put this up just because it was a funky looking building, and also because to my mind it's probably architecturally brilliant, survey wise a little bit more challenging with those curved edges and the tiers and so on, and also because it's mixed use. And I've said to many people that the Unit Titles Act actually doesn't deal with mixed use developments very well, because we have this idea that levies are only set and paid on a very strict basis, based on utility interest, and that's usually based on ownership interest, and therefore usually set by a developer right at the start. And once you've set that, it's proved very, very difficult to change, and proved absolutely impossible to set levies in any other way. So the courts have been very strict in saying you cannot set levies differently. And despite the fact your commercial units on the ground floor might be using 4 times as much rubbish disposal facilities, or have very different needs. About that. Very different needs or traffic. You do have this issue of how to allocate costs in a different way rather than strict utility interest, and that's proved absolutely impossible. And I know various people are trying to work their way around it, but the courts have been very strict. Another old style unit plan. I like this one just because it's very, very clear in highlighting what is a principal unit, what is an accessory unit, and what is common property. We have this, what looks like a big lift shaft in the middle. We have these areas outside. We have a clear boundary on the left and right. Things aren't always this clear, but when they are, it's pretty good. And I'll come to some of the issues around lack of clarity later, because that's where there's real value add from a surveyor in terms of precision and correctness on the unit plan. I wanted to put this up as a slightly newer title plan. I've cut and pasted and done things with it, but we have this idea of existing titles and principal units deriving from those titles, and I'll come to some of the issues around that. We have a combination of principal and accessory units, and obviously with their own record of title references. And we have here, again, a newer school unit plan, which is reasonably clear on defining different areas, accessory units, principal units. You look at area N, we have a line of veranda above. We have those dotted lines I talked about before. We have narrow issues of detail. If you look on the right-hand side of where the plans are marked, we have a dotted line and then a small space before the actual unit or development boundary. We have dotted lines outside the principal units on the bottom of the page to do with line of veranda or effectively an overhanging eave. We have canopy lines marked and so on. And those different areas are shown very well. And on the right-hand side, we have things like exterior faces marked, exterior face of wall extended, centre line of wall. These are all important aspects of precision, and again, that's one of the key messages to get across, because so many issues around maintenance and who pays for things later on can come back to exactly where those boundary lines are drawn. The courts increasingly have been a little bit flexible, I suppose, around how they treat boundaries and the sanctity of boundaries. But the key point for me is it's really important to get them clear and precise in the first place. You can't necessarily achieve everything you want to through clear boundaries, but they sure help a lot. So I talked a little bit about this idea of governance. I now want to just talk a little bit more about method of subdivision. A lot of this will be relatively straightforward for some of you, but we have this idea in fee simple land of a parcel of land that is owned extending from the centre of the earth up into the sky. So we can imagine a building on a piece of land, 3-storey building here, and then we imagine dividing that in simple terms into 3 different units. And unit titles were invented mostly to achieve this idea of vertical subdivision without the complexities of different easements and what would be called stratum estates and so on. So unit 1, unit 2, unit 3, we go up, we get better use of land through going up, we get more efficient use of land through private ownership, we get better economic outcomes for a developer by using one bit of land to create 3 different ownership parcels, and away we go. Then we get a little bit more complicated because we add on accessory units and we add on common property. And here we've got principal units 1, 2, 3, accessory units 1, 2, 3, an area of common property, whether it's a stairwell or lift shaft. And then we come back to that principle I talked about earlier, where even areas that are not marked as common property, such as above the upper height limits of units, are still common property. And we have all these issues, I'll get in trouble for showing a theodolite, but all these issues around, as I said, mixed use, around markings of units, around intensification of urban areas, around council planner views on car parks, and all those sorts of things that go into the development process. The mode of governance aspect is something I just want to spend a few minutes on, because And it's really important to understand what you're getting when you create unit titles. And I know some people like to create them because it makes sense in terms of a planning framework, or it seems the obvious choice. I do get an increasing number of queries around setting up an incorporated society rather than a body corporate. I flippantly say sometimes I think cross leases will make a comeback. Don't think they will, but there is a whole level of bureaucracy and compliance around unit title ownership that isn't for everyone and isn't for every development. So as soon as you go into unit title territory, excuse me, you've got the situation where your owners comprise the body corporate. All owners must join the body corporate. Body corporate has various duties such as ensuring the development. It must have a chairperson and must have a long-term maintenance plan. It cannot avoid these in a statutory compliance sense. Yes, there are many, many body corporates out there that do not have a functioning chairperson, do not really have a functioning insurance policy and so on, but they should. That level of statutory compliance is required by law. No way around it once you go with unit titles. We have the statutory framework, of course. And a key thing to think about here is what happens after you deposit the unit plan. You have this funny type of ownership, which I think is a combination of property law and corporations or company law. So once you buy a unit, you have to become a member of the body corporate. It's generally treated like a company, perhaps better compared to, say, a Māori corporation or sometimes a public law entity. So a body corporate must act reasonably when exercising its powers. It can't be completely unreasonable. We have this idea that's come through at Supreme Court level that being an owner of a unit title is a bit like being in a joint venture. You go ahead and carry on this joint venture according to body corporate rules and so on. This seems to me a very strange idea, but it is something the Supreme Court has said. The reason I think it's strange is that really a body corporate is nothing like a company or joint venture. It's not carrying on a business. It's a way of binding owners together to ensure they can make decisions and have to follow other people's decisions as well. This is my own description. It's a bit long, but I'll go for it. When you buy a unit, you're not just buying the unit, but you're also buying membership of the body corporate, which is like a club. The body corporate may pass rules you don't like, elect committee members you don't like, or decide to raise levies that you don't want to pay. Some of these reflect statutory obligations. So, for example, the body corporate must make sure the development is maintained properly. Some just reflect that people are different. Everyone is different. Understanding that you're buying into a collective is important, and not everyone is suited to being in a club like that. This is a challenge and a problem because increasingly unit titles are the only form of new tenure available in densely populated urban centres and even in sometimes in new greenfield subdivisions. There isn't an alternative always, and what you're buying into is a collective that you're part of, and that's why it's very important to consider, is this the right form of tenure really? Is this suited to what the developer wants to achieve, and is this going to suit owners in the future? Returning to subdivision issues, you can subdivide fee simple, leasehold, or a crown license. You create 2 or more principal units, accessory units, and some common property. You can't create sub-leasehold unit titles. That's in statute. And as I said, common property doesn't have to be described on the plan. Principal units, accessory units, and common property. Also, FDUs, won't get into them in great detail here, but happy to talk about them separately. Talked about before, principal units, accessory units, common property. Pretty simple in terms of those key ownership concepts. You must specify the building, if any, on your unit subdivision plan. And when you deposit your unit plan, you create this special form of ownership, a stratum estate. and that has a fee simple or a leasehold aspect, and by far the great majority are stratum and freehold rather than stratum and leasehold. You also have this beneficial interest in common property and a contingent entitlement on cancellation of the unit plan. So when a unit plan is cancelled, owners end up with a share in the fee simple. And that's happened following Christchurch earthquakes and also in some other cases. We have this idea of a layered development, and to give a simple example, you have units 1, 2 and 3, and you further subdivide unit 3, so you get principal unit 3A and 3B, and that becomes its own body corporate, potentially with its own rules, with its own levying mechanism, and those owners together have the opportunity to vote at the senior body corporate level. So, as I said, head and subsidiary unit title developments. Now, these haven't seen a lot of take up, but I have seen some emerge. My concern has always been about diluted ownership and voting rights. So, if you do create the subsidiary development, then you have this idea that you're going to have less rights to vote in relation to overall body corporate matters. And there's going to be challenges, I suppose, around making sure your voice is heard within this democratic framework. This is the diagram that appears in statute. I think it envisages more complex types of subsidiary developments than yet exist. So we have that blue level, which is the head development. We have a subsidiary development, pink and yellow, and then we have yellow unit 2 further subdivided into green. So we have these different levels, and I do think that would get probably too complicated too quickly. It becomes very hard to make decisions. So the mechanics of a layered development are subdividing a principal unit into further units, 2 or more principal units, accessory units, and common property. This itself requires a special resolution process. You deposit a plan to create that subsidiary development, and the principal unit that was subdivided remains part of the parent body corporate. Again, not that common, in my view, not always that desirable, but available. Stage developments are still more common. The idea here, going back to Unit Titles Amendment Act 1979, was that a developer might want to create one unit in a series, one building in a series, and then do another building later, and then do another building later. But creating these titles and stages would make it easier to finance the overall development. So we have these further concepts. We have this idea of a proposed unit development plan, which sets out what's to happen for the entire development. We have these further stage unit plans, and these stage unit plans are deposited as you go. And then we have a complete unit plan, which winds things up at the end. So each stage is going to set out completed works, plus your balance land as a future development unit, or FDU. And FDUs have caused all kinds of challenges, particularly under the 1972 Act, because the Act envisaged that they would not be completed and therefore would not vote or pay levies. And some developers worked out, well, they could build a building there, live in it, and never complete the development and therefore avoid paying levies. And of course, therefore, case law emerged. So when you've finished, you do your complete unit plan, and you put in your stage unit plans in substitution for each other. Each stage unit plan and the complete unit plan must include the territorial authority certificate that it's consistent with the proposed unit development plan. So we get into, unfortunately, acronym territory. And there's this idea that your stage unit plans can follow existing district plans, even if there are changes. So there is an easier ride, I suppose, in terms of getting through 223 certificate purposes under the RMA, even though there's planning changes happening. Your proposed unit development plan sets the framework for how that development is to be achieved. And as I've said, each stage unit plan creates a future development unit for the balance of the land. So principal unit 1, 2, and an FDU. We exclude parts of the RMA in relation to stage developments, and your 224C certificate can apply to the proposed unit development plan or each stage. So there's the alternative there, and potentially a bit of strategy making around which is going to be preferable. Your 224C RMA certificate can deal with particular conditions for a particular stage rather than the whole development. And again, that can make it easier to get through the hoops of a territorial authority. Difficult to change your proposed unit plan. It can be done. It used to be almost impossible because it required unanimity, but now it's only a matter of the special resolution, 75%, but still serving, notifying each owner and giving them the opportunity to object, which they don't often do. I mentioned it before, the importance of precision with unit titles, obviously important in all survey work and probably arguably all spatial work as well. But we start off with this idea that to deposit a unit plan, your record of title must not be limited as to parcels. And more particularly, you've got to have only one record of title that you're subdividing, unless the land is capable of being held in only one. So, for example, you can have two adjacent titles with the same owner. They would be capable of being held as one, so they can be subdivided into various units. Has to be all of the land in a record of title, and there's a requirement for the consent of a mortgagee or charge holders. There's also requirements for special territorial authorities approvals. So the development work must be completed to an extent that enables the unit boundaries to be measured. That's generally essentially framing, and must conform to the definition of a principal unit. So it must be defined in relation to a building or a car park. The Unit Titles Act 2010 allowed a car park to be treated as a principal unit. We have an extra step in the subdivision process because we have this need for a certificate from a valuer as to ownership interests. And again, that's part of the communication between lawyers and surveyors involved in the subdivision process to make sure they are clear as to who is engaging the valuer. So the valuer is ready ahead of time with their certificate. Again, if there's a layered development, there's further requirements. Talk about Section 33 exclusions, so things like two records of title that have the same ownership and can be held together, still allows unit plan to be deposited, requirement for compliance with Cadastral Survey Act rules, and grounds for a territorial authority officer to refuse to give their certificate. And again, that's essentially based on the building being incomplete. It wouldn't be usual to get to that stage and have a district plan contravention, but possible. And again, provisions around territorial authority officer requirements and legal rights and protections from liability. Skip over those. When you deposit a unit plan, you get a separate record of title for each principal unit and each future development unit, and the record of title for the base land gets cancelled. Your record of title includes the principal unit and accessory unit, any accessory unit together in one, and there are then restrictions on transferring accessory unit. So you can't transfer an accessory unit outside the development. You can only transfer it to another owner within the development. If you want to do something different with it to try to transfer it outside the development, you'd have to go through a redevelopment process, which I'll come to. Similar requirements for a layered development, but again, when you create unit titles, you're creating this bundle of rights and obligations, and so you can't get a separate record of title for your base land or for different parts of your stratum estate. As I mentioned before, unit titles look different. The front page is relatively similar, but you have this idea of a supplementary record sheet, and that will record that the body corporate owns the common property with a benefit beneficial entitlement accruing to owners, and that will have memorials about interests relating to the base land and the common property. So an obvious example would be an owner's mortgage appears on the front page of the title, their own identified record of title. Easements relating to the base land, they will appear on the supplementary record sheet. And notice of body corporate operational rules will also appear on the supplementary record sheet. We do sometimes have questions and issues about where, for example, resource consent requirements should be recorded. Consent notice will often go on the underlying land, therefore be shown on the supplementary record sheet, but can in some cases be shown on the individual owner's title. It's just a matter of how things are set up, and that's where I suppose some conceptual thinking is required about what are you trying to achieve and how this is to bind owners. Provisions around subsidiary developments and replacement unit plans, not going to go into here. So again, we return to this, and sometimes have debates around the office around what the purpose of subdivision is, because to my mind, what you're trying to do when you subdivide land is create titles. The whole point of the exercise is title creation. And you want one of these because then you can sell it and transfer it, and developer can make money out of it. From an e-dealing point of view, a little bit different, because conceptually sometimes what we're doing effectively is giving effect to a unit plan or an LT plan. We're just really helping the surveyor deposit that, is essentially the effect. And I guess that's an important question to keep in mind. Again, doing survey work or working with lawyers, what is the purpose of what you're doing? Is it simply to deposit an LT plan? Is it to create titles? Is it to help implement to get titles so that you can then sell them down and implement a sales program? Or is it something more in terms of creating good developments that stand the test of time afterwards? So important again to think about those conceptual questions. In this case here, coming back to that record of title, individual identifier, individual registered owner, individual mortgage, all shown on that record of title. There is reference to the supplementary record sheet, and that looks a little bit like this. That shows the plan number, what this was a subdivision of, the prior reference, and the unit titles that arose. So if we were trying to search every title in development, we've got a list of them there. Then we have the interests shown on that supplementary record sheet, and I've transferred them over here. So every supplementary record sheet contains this slightly odd memorial saying that the body corporate owns the common property and the owners have a beneficial entitlement to that. And the reason for doing that is to help with the transition to the Unit Titles Act 2010, all those years ago. We then have an underlying easement, so there's a party wall right that existed long before these unit titles were created. And we have also here a notice of change of body corporate operational rules. So that's also shown on the supplementary record sheet. And lawyers and surveyors cannot ignore the supplementary record sheet. We have to look at both the individual ownership and that collective ownership aspect as recorded on supplementary record sheet. Page 1, individual owner. Page 2, supplementary record sheet. Page 3, here is our unit plan. And again, I've talked about this one a little bit already, 1972 Act unit plan, and shows some individual units, relatively small dimensions. I'll come back to unit plans, but I wanted to, I guess, show the 3 different stages or pages of that title. Redevelopments are one of the particular tools in the Act. I have found generally they're much harder to achieve than people think. It's got to be a real willingness and reason to do so. They're very hard to achieve under the old Act because they required unanimous consent. So the 2010 Act was designed to make things easier. So we have this idea, firstly, of a minor redevelopment, a boundary adjustment with no material impact on common property or other units. It's an application by those unit owners and a certificate from the body corporate. We have here an amended unit plan with the boundaries of the altered units and a valuer certificate as to any ownership interest changes, and new records of title get issued. So haven't seen actually that much take up on this, but the mechanism was there or is there to affect a minor redevelopment. Anything that's not a minor one is a major redevelopment. And this is something that does materially affect other units or involves common property. What we find in practice is that almost anything seems to involve common property and therefore becomes a major redevelopment. So this process involves getting the consent of those materially affected and going through a special resolution process. In this case, it's a special resolution that's also a designated resolution. That means not just 75% of unit owners at a general meeting, but also serving or notifying all unit owners, all mortgagees, all charge holders, and giving them 28 days to object. I'm not actually aware of any owner, mortgagee, or charge holder ever objecting, but their right is there to do that. You then get a new unit plan which defines the altered units, new territorial authority certificate, a value certificate, and a process for reassessment of utility interests, and again, new records of title. So that would be the way that you'd convert an accessory unit into a principal unit, as this is unfortunately the mechanism that is there. This is the way you change boundaries of units other than that minor boundary adjustment. I want to talk a little bit about incidental rights, and I'll come back to this with some of the examples I give. But the essence of incidental rights is that they give each unit rights over other units plus the common property for services, effective as if they were easements. Therefore, you don't need to show an easement between Unit A and Unit B on a unit plan, because they will simply have those incidental rights in place. The scope of these is relatively unclear. When they drafted the 2010 Act, they chose to make it a little bit clearer than the 1972 Act, but not a lot. They have rights and responsibilities as if they were easements, but no clear implied terms or anything like that. There's only a little bit of case law, most of it's fairly old. Having said that, these issues don't actually come up that much. If you are clear enough on your survey plan around where unit boundaries are and where common property is, the services just seem to take care of themselves most of the time. Briefly mention this idea of if you've got a major remedial project, you can go to court to get a scheme to approve that remedial work being done. Because a scheme in reference to remedial works is a nice segue into the topic of maintenance. And the area of maintenance of unit title properties has been absolutely fraught with difficulty, because under the 1972 Act, the courts spoke very clearly about this fundamental distinction between common property and unit property. And the body corporate could only repair common property, couldn't repair individual units. So when we had a development like this, the big question the courts asked themselves was, how had the survey plan been drawn up? And once they'd got an expert survey opinion on that and decided that the roof was common property or not, that would then resolve how the building was to be maintained. And if the body corporate was supposed to look after the roof, but the roof was unit property, then the body corporate simply could not do that. So surveyors had a very important role to play. Things are a little bit more flexible under the Unit Titles Act 2010, not a lot, but a little. So we have this idea that the body corporate repairs and maintains not just common property, but also building elements. And a roof is very clearly a building element. Therefore, it's very clearly the body corporate's job to do it. It's not an individual unit owner's job to repair the roof of the building. It's going to be a body corporate job. Becomes still then very important to mark boundaries of common property, though, walls, doors and roofs, because even if the body corporate has the job of maintaining it, the question of who pays for it can depend on unit boundaries. And if it's clearly for the benefit of one unit or clearly within one unit owner's boundary, then even though the body corporate has to do the work, the cost of paying for that work can fall on the unit owner. So still important to get the boundaries clear and accurate. I'll be honest, my universal view is that let's treat building exteriors as common property, unless there's a really good reason not to, because common property should be external exterior areas, because that's going to make it clearer that everyone's in this together from a building point of view. So I've put up this particular unit plan just because this caused some interesting issues around unit boundaries. We have some areas of common property, essentially ducts within units. In this case, we had doors, and it wasn't entirely clear how those doors sat in relation to common property. So let's take the example of unit 33D, and we have a slight inset for the door, but we weren't actually clear from looking at this whether the external face of the door was unit property or common property. The client should almost certainly have got a survey opinion on that. They sought something less formal. We have a description here: principal unit boundaries, internal face of external walls, windows, balustrade, internal face of walls adjoining common property, centre line of walls between principal units. That didn't quite delineate or define the external face of doors, and of course, as it does in unit titles world, that caused an issue. So I'm just highlighting that as a particular one. This unit plan, which unfortunately isn't quite in the centre of the page, I showed it before. This is an example of one which does show different accessory units, different principal units. We've got exterior face of gutters, fascias, soffites, edge of concrete, face of canopy, lower limits, and so on. So we have exterior faces, I think, are defined in quite a good way. And what I'd encourage is the higher level of detail, the better, because if a lawyer is picking up a plan later, they can read and interpret it more simply, and any unit plan, to be fair, is not a simple exercise for lawyers. Some issues, and some of you will have heard these before, and some of you won't. Common issue in practical terms is where the building is built up to the boundary, and that's the boundary of the development, and then you have an eave which extends over a footpath, for example, which might be council property. And there's not necessarily an easy answer. What the Chang decision did in Auckland with a relatively prominent balcony was to clear it a fixture. And being a fixture, it was treated as adjacent to some of the units, and therefore those unit owners' responsibility to pay. There was argument, in that case, around whether it should be treated as covered under incidental rights. This idea that overhanging eaves and so on in place at the date of deposit of the plan are protected, but no, the court in that decision took the view that the balcony was a fixture, and recognised, however, that it was in fact part of the development, even though it was outside the strict envelope of the original fee simple land. Some issues that come up from time to time. One of them recently was to do with a resource consent requirement that there be a fire hydrant within the development, and that there be some legally enforceable mechanism about giving effect to the obligation of owners to maintain that fire hydrant. Council, for whatever reason, didn't want to do this through consent notice or a 1082D covenant. The very easy answer from our point of view was to put in place this maintenance requirement in body corporate operational rules. What I want to highlight, however, there is the need to be very careful when putting things into body corporate operational rules, because the general gist or tide of case law on rules in New Zealand is that many of them are unenforceable on the basis that they're ultra vires and outside the powers of the body corporate. So body corporate probably can maintain a fire hydrant for the benefit of unit owners. Rules themselves may or may not be able to perfectly allocate responsibilities around those. And again, we have to remember that putting aside overall responsibility, payment is another matter, and it will be very difficult, probably impossible, for rules to change the levying provisions that are set in stone in the Act. So if you want only some owners to pay and not others, you'll have to look very carefully at how the unit plan is set up and how you're trying to allocate those responsibilities. Airbnb is less of a topical issue than it used to be, but there have been significant issues in New Zealand law about whether body corporate operational rules can restrict Airbnb within a development. And inevitably, there's some owners that want to restrict it and some that want to get a lot of use out of the unit through Airbnb. And no fixed answer. There's been some case law which has said, usually at tenancy tribunal level, which has said that rules cannot restrict use. There's been other case law and some at tenancy tribunal level, which has said that body corporate operational rules can restrict use. And so there's been a lot of uncertainty, no real test case purely on Airbnb as yet. For what it's worth, case law in Australia has come out differently in different states as to whether this can be restricted. But what I'd encourage people to do is to be more certain about restricting use through use of land covenants rather than rules, and saying that no retail on the ground floor or only approved retail on the ground floor or no Airbnb or any use restriction like that is going to be more enforceable through a land covenant than through a rule. And there is this general trend, something I've spoken about at conferences elsewhere, that the unit titles is really about the law of buildings. And I highlight that because there's a lot of emphasis these days on talking about community and the importance of community and so on. There's also some sociological literature which says communities are defined by who they exclude rather than include. That's a different issue. But really where the courts have come down is saying the building is a very important part of a unit title development. That sounds obvious, but issues around maintenance, issues around remedial repairs and so on often come back to the context of the individual building and sometimes the survey plan that reflects that. So it is important to be aware we're not just dealing with people and personalities, we are dealing with fixed assets, i.e. buildings, and the way they're recorded and the way ownership of them is recorded through a body corporate mechanism and of course through titles and of course through survey plans. That's all I wanted to cover. I'm happy to take some questions. I just have to make sure my Slido app is working perfectly, but what I'm going to do is I will stop sharing my screen and invite any questions. I can now see myself. I'll just click into the Slido link. Right, I've got a few questions here, so I'll click into those. For a double-storied building with 2 units, 1 unit on top of another, should the units include the foundations and roof, or should these be held in common property? So my comment there is I would prefer the foundations and roof to be common property. One is that conceptually, I think that they are for the benefit of the entire development, and therefore it makes more sense for them to be commonly owned rather than ownership to fall with one individual owner. But I also think that's how the courts are approaching things as well. The courts are emphasising that building, because of the law of buildings aspect, owners are all in this together. If there's a problem with the roof, then the court's approach is that everyone should contribute towards this, not simply an individual owner. And that comes back to, if owners are all in this together, it makes sense to have the ownership set up in that way. Question, do stage developments still only have one body corporate, or will each stage create a new body corporate like a layered development, or is that dependent on what each stage does? So a stage development, to answer the question, will only have one body corporate. The body corporate auspices, I suppose, expand as more units are built and constructed, but it's still only one body corporate. You can hypothetically have a development which is both layered and staged. That seems way too hard to get my head around, so I won't try to go into it today. But there is this idea that staged and layered developments do exist. But to answer the question simply, staged development, only one body corporate. Question, even if the underlying parcels of a unit title development are held in the same ownership, would you recommend an amalgamation of the underlying parcels to form one base lot prior to the unit plan? Not necessarily. There'd have to be some driver for that, I think, is my answer. I've certainly created unit title subdivisions and developments over two separate titles where there's been the same owner and they could be held together, and that didn't seem to cause any problems. I'm aware of you can either have an amalgamation condition in place or simply seek that single record of title, but we took the view that this developer wanted to do the minimum level of compliance necessary to achieve what they wanted to do. So that's what they did. Further question, when unit titles are used for detached standalone units, should building exteriors still be common property? Very good question, and we are seeing unit titles used more and more for standalone buildings. Look, my view is yes. I still like this idea that building exteriors are common property, because the way I trace through those legal questions is often it's going to be the case that the courts are still going to say, first of all, there's a question about whether the building element relates to or serves more than one unit. Well, if it's a standalone unit, it should really only relate to or serve that individual unit. But the statute and the courts have allowed this idea that units can relate to or serve each other physically or economically. And where that seems to have taken the courts is an idea that if one unit is damaged and not repaired, then that's going to have a value impact on other units in the development. Therefore, we're going to try to relate everything so that everything gets repaired. We're going to get away from the idea that individual unit owners make their own decisions separately from the body corporate. We are going to have the body corporate responsible for repair and maintenance, and then only looking at recovery. And so if we have this idea of, let's say, 5 individual standalone units, let's say one of them needs repair 1 year, and then another one needs repair another year. If you've got a consistent framework for that, which you would with common property, that's very clear to everyone. If you have individual units owning their own exteriors, then you do have an issue of, well, this owner over here repairs it themselves because they think they can, and then this owner over here thinks that the body corporate should pay for some of it, and that this owner over here has bigger issues because of something else or an inability to pay. Whereas having it all as common property creates that framework where the body corporate is always going to have to do it, and that's going to create that level of consistency. Body corporate's still going to have to look to recover from individual owners. It should be able to in those situations under section 126, because the individual owner benefits more than other units. But having exteriors always as common property. It makes it very clear it's always a body corporate problem to look at repair and maintenance. A couple more questions coming through. Is it best to have cladding between PU and an AU balcony as common property? Yeah, I'm aware of this being done, potentially. I guess it comes back to what you're trying to achieve. And if you're trying to achieve this idea that it's always going to be the body corporate's job to maintain that small area of cladding, then keep in mind the broad issue of broad trend of case law is that the body corporate's probably still going to have to maintain it anyway, because the courts have this strong interest in consistency and probably not drawing clear delineations between this is private property and this is common property. Question, windows. If unit boundary is defined as the middle of the exterior wall, but windows are not specifically mentioned, how have this been interpreted? Yeah, very good question. I'm actually not aware of any case law which has looked specifically at windows, but again, they will be treated as a building element. So again, it's going to be a question of this idea, which is not a survey question, unfortunately, but of a building element. And the building element is anything that's relating to the building as a whole, structural matters or health and safety matters or aesthetic matters, so it has a broad definition, and the body corporate's still going to have to end up looking after the window, probably in most cases, depending on building design and so on, because again, it's contextual. So I would like a level of detail which says all external faces, including windows, are common property, for example. A bit difficult to get to the midline of a window, but again, what we're trying to achieve is clarity. Is there a way to subdivide a single unit into 2 or more units and have both units still managed by the head body corporate, so not a layered development other than by a redevelopment? Not really. If you're subdividing a single unit into 2 units, you're either going to have a redevelopment or you're going to have a layered development, so one or the other. And again, that comes back to let's get the concept of what's trying to be achieved right first time. Just flicking through the different questions. I think I have got through all the ones that are showing now. So look, it's 10:58. Thank you for watching. Thank you for your questions. They always get me thinking. For those who need my email, or you can always Google me, find me, and feel free to ring up and ask a unit title question or email it through. I take those kind of questions all the time, and actually I learn a lot from them, so I really like them. If you have particularly interesting examples, I'm really interested in hearing them too. I won't necessarily use them in this kind of presentation because I tend to use examples I've come across, but always really interested because every issue like that is a learning experience. So thanks again, everyone, and I'll leave you to the rest of your Friday. Have a good one, and I'll hand back to Jenny. Thanks.
Hi, thank you very much, Thomas. And also thanks again to all of our attendees for coming online. And as Thomas said, if you do have any questions whatsoever that you want answered regarding unit titles, please either contact Thomas or email them through to me at Survey Spatial. That's Jenny at surveyspatialnz.org, and I will forward them on to Thomas. So once again, thank you, everybody. Enjoy your day and have a great weekend. Thanks.
Cheers, thanks.